Imagine stepping into a courtroom today. Cameras flashing, social media buzzing, the faces of strangers on TikTok judging before the verdict is even read, AI-generated deepfakes floating online of witnesses and lawyers, the trial being streamed live to millions who have never set foot in a room, and yet at the center of it all still sits a jury. 12 ordinary people asked to decide extraordinary questions of guilt, innocence, life, and death, but this institution that we so often take for granted has a story older than nations, older than modern democracy itself. A story born not in polished courthouses, but in the crowded streets of Athens more than 2,000 years ago, where citizens gathered not as spectators, but as participants, men drawn by lot, hundreds at times, who would sit on stone benches and hear the pleas of their neighbors, not guided by lawyers or bound by the technicalities of procedure, but by the raw voice of rhetoric and persuasion. For in Athens a jury was not simply a body to decide law. It was a very heartbeat of democracy, a safeguard against tyranny, an assurance that no ruler could judge alone, that no citizen could be silenced without the ears of his peers hearing his cry. From Athens the idea slumbered and transformed, carried across centuries to medieval England where the great weight of the Magna Carta, in 1215, put ink to parchment with words that still echo. No free man shall be seized or imprisoned except by the lawful judgment of his equals or by the law of the land. And though those words were meant to restrain a king and protect barons, they sowed seeds that grew into the promise of trial by jury, a promise that in time would cross oceans and take root in the soil of the American colonies, where mistrust of crown-appointed judges made the jury not just a legal mechanism, but a shield of liberty. In colonial America, juries did more than decide facts. They defied authority, as in the trial of John Peter Zenger in 1735, where a jury acquitted a printer accused of seditious libel for criticizing the governor, laying the groundwork for what would become freedom of the press, a moment when the jury became the people's veto against unjust law. Fast forward to the birth of the United States, and you see the jury woven into the Bill of Rights, the Sixth and Seventh Amendments enshrining the right to a jury in criminal and civil cases. The founders believing that without juries, judges could become tyrants. Law could become an instrument of oppression rather than justice. Yet the jury has never been static, never frozen in time. It has been challenged, reshaped, limited, and defended across generations, from Jim Crow-era exclusions that denied black citizens a right to serve, to the long fight for women to be included, to modern reforms questioning whether 12 strangers can still represent fairness in an era of mass media and information overload. And so we arrive again in the courtroom of today. But now the threats are not kings or governors. They are algorithms, viral misinformation, and cameras that turn every juror into a character in a global drama. Consider the trial of O.J. Simpson in the 1990s, where the jury was sequestered for nearly 9 months, shielded from newspapers and television, but unable to escape the looming sense that the entire world was watching, a trial that revealed how media can transform jurors from anonymous decision-makers into unwilling celebrities, their every choice second-guessed by millions. Today, that spotlight is brighter, more invasive, as live streams broadcast testimony in real time, as Twitter threads dissect jurors' facial expressions, as TikTok creators spin conspiracies from the smallest gestures. And in this environment, the sanctity of the jury room, once shielded from outside noise, feels more fragile than ever. But if you think this is merely a modern problem, history whispers otherwise. For in every age the jury has been tested by the technologies and pressures of its time, from pamphlets and broadsheets that swayed colonial juries, to newspapers that sensationalized trials in the 19th century, to radio and television that made 20th century cases into national spectacles. What is new, however, is the speed and scale at which information now moves, where a single viral clip can shape public opinion before jurors even leave the courtroom, where artificial intelligence can fabricate convincing audio or video that may slip into the discourse surrounding a trial, raising the terrifying question: how can jurors discern truth when even reality can be faked? And yet the jury persists, evolving, adapting, sometimes stumbling, but always return to the same core belief, that justice must not be the province of the powerful alone, that ordinary citizens must sit in judgment of their peers. Consider the debates now rising in legal circles. Should jurors be allowed to deliberate remotely, meeting over Zoom as they did in some pandemic-era experiments? Or does justice require solemnity of a shared room, the human presence that tempers isolation and forces consensus? Should cameras be allowed to broadcast trials in the name of transparency, or do they distort proceedings, making jurors self-conscious and witnesses wary. Should jurors be shielded from social media entirely, or is such shielding now impossible in a world where smartphones are never out of reach? Each question feels modern, urgent, but each is also haunted by history, by the same tension between openness and corruption, transparency and manipulation, fairness and spectacle. We are left to wonder, is the jury still capable of delivering justice in an age when public opinion forms before verdicts are reached, when narratives are spun faster than facts, when algorithms decide what people believe before evidence is weighed? And here lies the suspense. The enduring mystery of the jury, that fragile but resilient institution that has survived kings, dictators, revolutions, and reforms, now tested again by the digital age. Will it bend or break under pressures of technology and mass media, or will it once more adapt, carrying forward that ancient promise from Athens, from Magna Carta, from Philadelphia, that no one should face the way of the law alone, that judgment belongs not to rulers or machines, but to the collective conscience of ordinary citizens? For in the end, the story of the jury is not just about law. It is about power, about who decides truth, about whether justice belongs to the people or to those who can manipulate perception. And as we watch today's trials unfold on our screens, as we scroll and comment and speculate, we are all, in a way, shadow jurors of a digital age, witnesses to a new chapter in the oldest struggle of justice. Who gets to decide? And can we trust a verdict? Subscribe, like, and share for more.